So let me walk through a scenario. There's a physician practice that intentionally or unintentionally there is something questionable going on. An employee gets wind of this in some form or another. They decide that they think there's something wrong. They call an attorney who can take them through this key temp process. What happens at that point? Does the government get involved? Is it all just a typical kind of a lawsuit from an individual? Walk me through the process from the time a whistleblowing employee goes to talk to an attorney.
It is anything but a normal piece of litigation. It has a very unique procedural set of requirements. The case has to be formed properly, investigated with what's called pleading with particularity. You basically have to come out of the box at the beginning of the lawsuit with a level of evidence that is beyond mere speculation. And you have to present that to the court. And that presentation is done under seal. No one knows it's happened except for the judge, the whistleblower, the attorney, and then the DOJ. The Department of Justice has to be notified immediately, and all of the information given to the DOJ. They conduct an investigation, typically secretly, quietly, maybe or maybe not involving the whistleblower. And then they make a determination whether they want to intervene in the case or not. And whether they intervene or not is contingent upon a number of things. Could be they don't have enough resource at the time, or they have another case that's similar in another location that they want to combine. A number of factors go into DOJ intervention. But the employer, the organization that is the defendant, they have no idea this is going on. And these things can go for months or years before becoming unsealed.
Does the DOJ have to agree to take the case, or if they don't, can the whistleblower proceed on their own individually?
The DOJ does not have to take the case. The whistleblower can proceed, and the attorney, therefore, begins to act on behalf of the government. So the
attorney is representing the government because they're the ones allegedly defrauded, not the whistleblower. The whistleblower has not suffered personal damage per se. They're just
from start to finish
raising a flag saying, hey, I think the government's getting cheated here.
Absolutely. From start to finish, the federal government is the party of interest here. They are the ones that have been defrauded. They are the ones that stand to get the recovery back. Okay. The difference between DOJ intervention and non-intervention to the whistleblower is significant, because without intervention, the whistleblower gets more of the recovery. Critically, through this process, to reemphasize, this is not a standard lawsuit. The requirements of an attorney to pursue one of these things are very unique and specific. So the best piece of advice a whistleblower can get is find an attorney who knows what they're doing within this area of law, and there's not that many of them.